Good afternoon, everyone. My name is Layla Benampour, and I'm the chair of the Natural Resources and Environment section of the Boulder County Bar Association. And I'm really excited about our CLE today. We'll be discussing the law of the Colorado River. Gregor MacGregor is our presenter. He's a water attorney who has practiced privately and in government. He currently directs Colorado Law School's Acequia Assistance Project, which provides pro bono legal services to underrepresented irrigators in southern Colorado. He also teaches the law of the Colorado River at CU Law, a field seminar culminating in a floating symposium down the Grand Canyon with subject matter experts. So, Gregor, welcome.
Alrighty, thank you, and thank you to you brave souls who are out here in the winter storm, the snow apocalypse as it's coming down outside the windows. If you're watching this later at home, I hope that you are curled up in front of a cozy fire, or that you're in a raft just like that. It's actually a dory, having both adventure and education. So, as Layla said, my name is Gregor MacGregor. It's not a joke, but it is funny, so feel free to laugh, and this is going to be our speed run through the laws of the Colorado River, that which you've heard about in the news constantly. All of a sudden people actually care about water law. It makes my heart glow that this is the case. So let's jump right in. So here's your first free water law joke. We'll be plumbing the depths of the pedagogy here. So step one, I'm going to be telling you what I'm going to tell you. Step two, I'm going to tell you. And step three, I'm going to tell you what I told you. Which, as attorneys, you all know, sometimes judges and especially opposing counsel need that kind of reiteration to know that you are, in fact, the correct one on any given point. So part one, telling you what I'm going to tell you. So we're going to go through river, comma, the law of. What exactly is that? What does it do? Prior appropriations impact on the Colorado River Compact, the compact itself, what it does, what it is, most importantly, what it got wrong, and then the Boulder Canyon Project Act, which is what provided Hoover Dam and really kick-started the development of the Colorado River Basin as a whole. Slightly going to talk about treaty with Mexico, and then we're going to talk about what's eating Arizona. So, big case in the 1960s where Arizona and California finally settled their old grudges in some ways, and then the Colorado River Storage Project Act, which authorized the Central Arizona Project. And finally, we'll talk about the structural deficit, drought contingency plans, climate change, and all the fun stuff that will keep you coming back to these CLEs for years to come. All right, part two, telling you. This is generally the response I get when I try to talk about water law. You get additional CLE credit if you can name the movie. Anybody? Anybody? Nobody even understands the water laws. So that's the Milagro Beanfield War, classic Robert Redford film about Hispano farmers down in New Mexico, full of, honestly, it's basically a water law course in that this quote is in it. So, river, comma, the law of. This is a photo from my student days of looking in the index in my water law textbook, and like, where is it? Where is this so-called law of the river? And what it is not a simple, succinct thing that you can look up in the back of an index. Instead, what it is a complex layering of compacts, federal legislation, state legislation, Supreme Court decrees, operating criteria. You've got it all. Admin law, state law, federal law, tribal and Indian law. We've got it all. So these are the major components of the law of the river. And for today, we will be doing the speed run of these components, which I told you about in the beginning. So we won't be covering every aspect of the law of the river. I try very hard to do that in a full semester-long course, so if you want to come, get your LLM, take my course, go down the river with me, please do. I encourage it. So, what is the law of the river? So this is the major body of law that affects almost all water rights distribution in Wyoming, Colorado, Utah, New Mexico, Arizona, Nevada, and California. Each state that either is touched by the Colorado or draws from the Colorado. And you can see there that it controls not just the main stem, but also major developments on the Green, the San Juan, the Little Colorado, the Salt River, and the Gila River. And you'll see here in the photo, you've got two different colors here. The lighter color is the upper basin of the Colorado, and the darker color is the lower basin. And you'll see that a couple states have areas in both basins, and that's because their tributaries flow into the Colorado either above Lee Ferry or below Lee Ferry, just below Lake Powell and Glen Canyon Dam. And that'll be important as we talk about the compact. But before we get to the compact, we're going to talk about prior appropriation a little bit. This is generally what people think of when they think about water law. This is first in time, first in right, Irwin v. Phillips, Coffin v. Left Hand, people loading up mules with dynamite and rifles and going up into the foothills and blowing out headgates, that real quintessential Western law that we love to talk about. And at the turn of the century, there's this big question of what is going to determine water rights between the states. Inside of each state in the West, we generally have some form of prior appropriation, but there was still this open question of, okay, do farmers on the Wyoming side of the North Platte have claims against farmers on the Colorado side of the North Platte? And here is Delph Carpenter, late great Coloradan out of the Union Colony. His idea, and the idea of many people in Colorado at the time, was kind of this sovereign domain idea, right? Every state gets to use as much of the water as it wants, arising within its boundaries, which for Colorado obviously is great since we're the headwaters state. We provide 70% of the flows to the Colorado River. So that was our preferred idea, and the one that was advanced by Delph Carpenter in exactly the dispute I theorized for you in Wyoming v. Colorado in 1922. And this was on the North Platte River, where Wyoming brought suit on behalf of its irrigators, saying that diversions in Colorado were injuring more senior irrigators on the Wyoming side. And while Delph Carpenter advanced this idea of, hey, if the waters arise in our state, we can do whatever we want, instead the Supreme Court said, we recognize prior appropriation, and we recognize that these states each recognize prior appropriation. So rather than doing an equitable apportionment, we're going to say that between states who are prior appropriation states, that's the law that will govern. So Colorado farmers, you can't develop past a point that will injure your downstream Wyoming neighbors. Obviously, this was a loss for Colorado and a win for Wyoming, but it got everyone in the basin really thinking about a larger scale problem. And that larger scale problem was California's development on the Colorado River. California, as you might expect, was developing at a much more rapid rate than all of its neighbors. Nevada, Arizona, Utah, Colorado, New Mexico, Wyoming. So knowing that this prior appropriation principle would hold between the states before the Supreme Court, this galvanized everyone to come together to say, okay, we should use the constitutional powers granted to us to come up with a compact so that everyone has water reserved for their own development on the system without the need to go to the Supreme Court and without the ability of California to essentially swallow up the entire Colorado River while the rest of us are just beginning to start putting in headgates and developing and building up our population in a way to catch up with the West Coast. And that's how we got the Colorado River Compact. In terms of what it is, it's not actually a compact between the states. It's a compact between these two basins that you saw on the map earlier. So in the upper basin, you've got Colorado, Wyoming, most of Utah, part of New Mexico, and part of Arizona. And the way this broke down was really along the lines of interests. Everyone came together for the compact negotiations, partly in Denver and then at Bishop's Lodge in New Mexico, thinking maybe we'd come away with state to state to state compact, but the way they worked it out was rather interests. There were distinct interests between the upper and the lower basin. So in the upper basin, they wanted a right to develop on their own pace and not to have that interstate prior appropriation soak up all of the water into California. They wanted to eliminate the threat of federal control, avoid litigation, and then develop their own comprehensive reservoir system. In the lower basin, California, Nevada, most of Arizona, part of Utah, part of New Mexico, the goals instead were to gain political support for construction of Hoover Dam and the All-American Canal. Now, Hoover Dam was an important component because at this time the Colorado River was running wild and periodic floods would come through and destroy parts of Yuma, destroy parts of the Imperial Valley, both in terms of lives, livestock, feed, food, infrastructure. You know, the untamed Colorado every few years would come through and just wreak havoc in the lower basin. So they were interested in flood control in a way that the upper basin wasn't, and in order to have the federal government sign on to build Hoover Dam, which was a massive expense, they needed a compact in place to gain the political support of the other basin states. Same thing for the All-American Canal. This is the canal that delivers water from the Colorado into California. Previously, those irrigators had shared a canal with their Mexican counterparts on the other side of the border, but they wanted a canal that was both technically better and would also just simply deliver water directly to American farmers in the Imperial Valley. Here are some of the basic allocations about what it does. So you've got 7.5 million acre feet for exclusive beneficial use for both basins. The lower basin also gets a bonus million acre feet. And you have this strange wording that is rather obtuse and not very clear. And this is a theme that goes throughout all of the Colorado River, the law of the Colorado River, and that the upper basin states will not cause the leaf area flow to be depleted below 75 million acre feet for any 10 consecutive years. Now, notice it doesn't say will deliver this amount of water. It says it will not cause to be depleted. It also doesn't ever define depletions. It doesn't define causation. And this is a major sticking point currently in the obligations between the two basins, that we have this really obtuse wording that no one knows what it means, and because we've never had to litigate or had to use the terms of the compact, 100 years later is still just as obtuse and unclear as it was the day it was signed. And then thinking ahead, Mexico, whatever water to be delivered from them will come from a surplus, and if there is no surplus, then that'll be split between the two basins, which is in fact what we're constantly doing now, because lo and behold, there isn't a surplus, and we'll talk about why in a minute. And then the last two articles that we'll talk about, there's one sentence considering Indian rights. The compact does not affect the obligations of the United States to Indian tribes. That's it. Nothing else. Okay, right. And Article 8, present perfected rights are unimpaired by the compact. And again, there's, for those of you who are corporate folks, mergers and acquisition folks, contract folks, there's no portion of the compact that gives you defined terms. So whether these present perfected rights are as of the date that all of the delegates agreed on the compact, whether this is the date that any individual state passed the compact, whether this is the date of the act that authorizes Hoover Dam and essentially adopts the compact, no one knows. So another point of ambiguity that very much likely was there so that everyone could go home to their states and everyone would be happy, that has left us with this legacy of question after question after question of what do we actually do if there is a shortage. And this shortage that we're dealing now, and the reason for a lot of this optimism that grew up around the law of the river initially and then subsequently throughout all the years, is because the compact got the numbers wrong at a very base level. So the delegates to the compact used what's called the Fall-Davis report, named after the authors, who said that there would be an average flow of 17.3 million acre feet a year of flow in the Colorado, which, you know, that gives you your 7.5 for both, your bonus million over to the lower basin. You know, Mexico will come out of whatever's left, and the tribes, well, you know, they'll come out of whatever's left too. And this number really allowed everyone, again, to go home saying, hey, look how much water we brought home. We're going to be able to develop beyond our wildest dreams. Sign, 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 sign. But unfortunately, this number was taken from flows at the Yuma gauge, so Yuma, Arizona. And some of the major issues around it are the sample set. So you're looking at 1902 to 1920, which we all know is, you know, the great wet years of the early 20th century. And then we say, oh, well, they couldn't have known, it was just the wet years, so that was their sample set, and too bad. But in reality, there were other engineering reports out there that showed considerably less flows. And some of these were based on other stream gauges in the area, including gauges at the Great Salt Lake, which show a pretty strong correlation between the lake's rise and fall and the amount of precipitation in the area, and that brought down the averages quite a bit in that report. And then dendrochronology as well, so looking at tree rings in the past to determine how much water was available. So simply the fact that Fall-Davis only took into account 1902 to 1920 set us off down the wrong track. And this was also not a naturalized flow. So naturalizing flows is something that water engineers do to say, okay, sans human development, what would be coming through here? And that didn't happen. So rather than averaging what a natural flow would look like, they averaged how much water was available, disregarding the fact that uses increased precipitously from 1902 to 1920. So the amount of water humans were using in 1902 was incredibly less than there was in 1920. But by averaging that out, they'd essentially said, hey, there's this water available right now that really was only available in 1902. And the use of water would never come back down to allow that average to be an actual average. And then, of course, they also disregarded uses below Yuma, such as most of the use in the Imperial Valley, and Mexican uses, and also didn't account for future reservoir evaporation. So that's it's a great roll-up of, hey, if you're a delegate to a compact or you're an attorney, you should really make sure you know what your engineers are talking about, and you should really investigate and interrogate the basis for whatever decisions you're ultimately making, which clearly did not happen here. A lot of the diaries, transcripts, etc. from the Colorado Compact negotiations show that people could not figure out the geography of where these measurements were being made, couldn't figure out the math behind them, didn't understand what was going on, but rather than stopping and bringing in experts or re-examining the Fall-Davis data, they just kind of brushed it off because 17.2, there's plenty of wire for everyone, we'll kind of figure it out down the line. So two people who did actually go in and interrogate this data, Eric Kuhn and John Fleck, both very respected on the Colorado River. Their fantastic book called Science Be Damned, 2 M's, which again, free water law jokes all day long. So Fall-Davis said 17.3 million acre feet. If you reduce that by the uses in California and Mexico below that Yuma gauge, you then drop off 2.7 million. If you correct to levels of 1920 development, again, that average, which really isn't an average, you need to be taking into account the use over all of those years in 1920. That's another 1.3 million acre feet. Ooh, upstream reservoir evaporation, that's another 2 million. So Kuhn and Fleck calculated that actual water available at Yuma using the rest of the Fall-Davis methodology was only 11.3 million acre feet. And this is where we get the structural deficit. You've probably heard about that quite a bit in the news of, hey, more water has been allocated than exists. And this is the underlying problem going all the way back to the compact that we're dealing with now is we've allocated and people are using more water than exists in the system. And while our reservoirs have allowed us to do that, storing water in excess years and then drawing them down, with increased aridification and the new normal, we've essentially been drawing down that bank account ever since the year 2000, which is why Lake Powell today dropped below the critical threshold of elevation for the first time ever, and the power pool and the pass-through ability of the reservoir is at risk. And it all comes down to, some really lawyer level addition and subtraction here, that if the delegates had chosen to actually bring in experts or use other more accurate reports, we wouldn't be dealing with today. Here you go, the E.C. LaRue paper, Paleo Reconstruction back to 1850. And you'll remember that the Desert Lands Act and many of the other reclamation acts of the late 19th century were in response to large droughts in the Southwest. So it's not like the delegates really could be forgiven for simply not taking into account things that weren't in recent memory. And this is the general, consensus of people when you talk about the compact who, know the bare minimum. Well, they did the best they could with the information they had. Terrible luck. No, you had the droughts. The commissioners did not seriously examine the data or bring in other experts. And then political expediency, always blame the politicians. Don't blame the attorneys, blame the politicians. They wanted to show they had plenty of water when they went home to get the compact passed in their states. And with that as the groundwork, we seriously began to build up both the law of the river and the infrastructure that allowed development throughout the West. So here we've got the 1928 Boulder Canyon Project Act. Extra points to anyone who knows the original name of Hoover Dam.
Boulder.
Bam, right there. It's right there in the title. So Boulder Canyon Project Act authorized the Hoover Dam and the All-American Canal. This legislation also consented to a 6-state ratification of the compact, limiting California to 4.4 million acre feet. The holdout in this case was Arizona. Arizona went home and could not get the terms of the compact ratified by their state legislature, which would kick off decades and decades of friction between California and Arizona, including the infamous Arizona Navy incident, where Arizona sent its National Guard to the border and put some boats out in the river to try to stop California and the federal government from building dam infrastructure. So don't say Arizona never had a Navy, because they did for about 6 months. This also consented to upper and lower basin compacts, which would be necessary for the states in each of the basins to break out their own allocations of those 7.5 million acre feet. And then it also authorized the Secretary to contract for deliveries from Lake Mead. And this is essentially what created the federal river master, which, perhaps the delegates to the compact who were still alive were very unhappy. As you remember, the upper basin very much wanted federal control out, right? This is the whole reason for the compact. But the reality on the ground is the federal government has the money and has the expertise to build these massive infrastructure projects. And in order to get the water out of those projects to individual users and states, somebody has to push the button or pull the lever. And in this case, that is the Secretary of Interior, but really the Bureau of Reclamation. Mexico finally got dealt with in 1944, guaranteed delivery of 1.5 million acre feet a year out of the surplus. If there's a shortage, both basins split it, which has been the case now for 2 decades. Both the lower basin and the upper basin have been contributing 0.75 million acre feet. They also get an additional 0.2 million acre feet in a surplus year. And we'll see this again and again throughout, where even in 2002, we were planning for surpluses. And whether that's simply being prudent in that, hey, if there's a surplus, we need to figure out what to do with it, or if it's political expediency, I'll let you take your pick. And again, on the theme of obtuse language, we've got the United States able to reduce deliveries during an extraordinary drought by the same proportions as consumptive uses in the USA are reduced. Again, there are no definitions here. We don't know what an extraordinary drought is. We're still not on the same page of what exactly consumptive use is in terms of the compact and interstate allocations. And so far, we've never declared an extraordinary drought, and we're now experiencing the driest period since 800, the year 800, and we still haven't declared extraordinary drought, so it's hard to imagine that we will. And even if we did, how exactly we would calculate the proportionate reduction in consumptive use as is happening in the United States, I'm glad I'm not an engineer and I don't have to figure that out. All right, 1963, Arizona v. California. So this is actually Arizona's third time taking California to the Supreme Court over the terms of the compact, or the fact that there is a compact. Lower Basin, obviously unsuccessful in negotiating a compact since Arizona wouldn't even assent to the original Colorado River Compact. Arizona continued to come to court because it could not get congressional approval for the Central Arizona Project, which delivers billions of gallons of water to Tucson, Phoenix, as well as all of the tribes and agricultural areas that run along its length, and that's because California would simply block it every single time. Absent the resolution of lower basin allocation. So Arizona sued the fourth time, finally won, and the Supreme Court said that Congress had already apportioned water from the main stem of the Colorado River in the Boulder Canyon Project Act. So the Boulder Canyon Project Act, which laid out California to 4.4 million acre feet, Arizona to 2.8, and then Nevada to 300,000. And that number is small because the Colorado really only touches Nevada right there at Las Vegas. And basically the Supreme Court said, look, this has already been figured out. Arizona and California, you can't agree over who gets how much water. We already did this, so we're just gonna adopt this wholesale. Again, there was really no discussion about what these numbers were based on or the underlying figures from the compact itself. Just again, building on that faulty foundation from the early 20th century. Arizona v. California was also a landmark decision because it decreed 5 American Indian tribes water rights who were on the main stem and created the calculations by which tribes would have their water rights calculated, and that is the practicably irrigable acreage standard. So the Supreme Court said, based on an earlier case called Winters, we know that these reservations were created to be, the agricultural footprint for native societies rebuilt in the European manner, right? We're taking these people who either are agricultural or are nomadic, and we want them to adopt our ways of farming. And in order to do that, obviously, even though it's not stated, all these treaties and reservations include the amount of water necessary to do that. And building upon that, how do you figure out how much water that is? Okay, you have an engineer look at the slopes, the kinds of soils, what area of the reservation can be practicably irrigated. Multiply that by the amount of water, and that's how much they get. So this was a major breakthrough for the tribes on the Colorado and really across the country in terms of how do we figure out both how to get water to the reservations and how much water that should be. And Arizona v. California, together with the Boulder Canyon Project Act, essentially work as a lower basin compact. The federal government is the river master. They contract and dole out the water underneath these limitations as set forth in the Boulder Canyon Project Act. The 1968 Colorado River Basin Project Act really shows the end of the dam building area, the great buildup, as Charles Wilkinson says, where Marble Canyon and the other dams inside of the Grand Canyon are defeated by the environmentalist groups. Central Arizona project is still built using power from the coal-fired power plants around Navajo. But Arizona would finally get its allocation of the Colorado River, above its uses in Yuma, basically. Unfortunately for Arizona, in order to get this through, and in order to get California's, key chairmanships and other machinations in Congress, they essentially said, yes, we'll get CAP built, but we accept that any shortages will come out of Arizona's allocation first. So in that 4.4 that California gets, 500,000 that Nevada gets, and then Arizona's chunk, Arizona would take all cuts to CAP prior to any cuts happening in Nevada and California. And then you've got some more great same character junior status language that's never really been tested, and everyone you talk to will have diametrically opposing views on what they mean, which is my favorite part of it. So here's a basic schematic of the river system as is controlled by interior and really impacts the main Colorado River compact and obligations. So in your average year, you're going to have basically 8.25 million acre feet traveling between Lake Powell and Lake Mead. And that's so that the upper basin gives their 7.5 million acre feet to the lower basin, as well as that portion of Mexico's allocation, because we're constantly in a shortage. So you can see on the right, you have your inflows, very minor tributary inflows there between Powell and Mead and beyond Mead. And then you have your average outflows from Meads, because there's not really use between the two. So what you can see there is 10 million acre feet outflow and a 9 million acre feet inflow. And this does change year to year. This is simplified, but this is, again, just highlighting that structural deficit that's been waiting in the wings since 1922, and that we've been steadily incurring really over the last 20 years. So this is a chart that includes basically all of our drought contingency plans that we've created in the last 20 years. So interim guidelines, the drought contingency plan, the binational water scarcity contingency plan between Mexico and the United States. And I know this is a whole lot of numbers, but the major takeaways are here on the left, you have Lake Mead's elevation, which acts as the triggering for all of these savings. And then you have reductions here, and you can see the 2007 interim shortage guidelines. All the cuts are to Arizona and Nevada, as envisioned in the Storage Project Act, meant 323 delivery reductions to Mexico. The drought contingency plan curtailments, these were passed in 2019, and you'll see that, again, Arizona takes the brunt of it, but California does eventually chip in some water, and then some reductions in the binational water scarcity contingency plan. And while, the DCPs in particular in 2019 were really heralded with all this optimism and all this fanfare of, look, we've cooperated under the terms of the law of the river to create these voluntary cuts so that we don't have to figure out what all of these really obtuse, purposely vague provisions mean. The major takeaway here is that only at the most drastic cuts, only at below 1,025 feet, do these cuts actually address the structural deficit. So any cuts leading up to what we consider a perilous tipping point here are really just, we're going to reduce a bit and hope that Mother Nature hits us with another 1983, right? That we turn around this periodic drought and get free refills and can continue to use more than is actually flowing into the system, which obviously isn't happening. We're 20 years into aridification, the new normal. There's doubts that we'll ever return to 20th century hydrology here. So really, this isn't enough. The lower basin has recently passed something called the 500 plus plan, which again is more voluntary savings from the lower basin states, but again, hardly even addresses this underlying issue. So that's fun. Cheery. All right, part 3, tell me what I told you. Here we are at the end of our speed run. The Emerald Mile was a famed dory whose crew rode down the floodwaters of 1983 that almost destroyed the Glen Canyon Dam, setting a speed record along the way. So that's why this is the speed run edition. It's a great book. I highly recommend it. So the Law of the River is actually a great body of work. This isn't a single statute. This isn't a single decision. This isn't a thing you can look up in the index of your water law textbook or in Black's dictionary, although I'm going to petition them this year to include it. Second takeaway, always double check your numbers. And I know this is scary, and I know it's hard. We're attorneys, we're not engineers, we're not accountants, but to the ability you can, make sure that whatever decisions you're making, whatever you're presenting, ultimately are backed up by the facts. And if you don't understand, you need to get your engineer on the phone and maybe get them to get a different engineer on the phone to tell you what it is that's going on. Because at this very base level, we've built up an entire body of law and really the livelihoods of 40 million people in the Colorado River Basin on a faulty assumption, on some really bad numbers. And many of the tough decisions that we have ahead can be tied directly back to those delegates not cross-examining their own numbers and their own assumptions. Which brings us to the fact that the structural deficit has been waiting in the wings forever. The fact that we have reservoirs and that they work the way reservoirs work, in that they store water in the good times and then we draw them down in the bad times, has largely masked the deficit over the years. So has the relatively slow development of certain states. The fact that the Central Arizona project didn't actually come online until half a century after the compact was negotiated had a big part to do with that. The fact that the upper basin only uses 4.5 million acre feet of its allotted 7.5 million acre feet has a lot to do with that. But this underlying math problem has always been waiting for us. And now that we've completely developed the river system, we now have to face that initial issue. Looking ahead, cuts are going to hurt and the structure of the compact will be tested. And how this plays out really depends on whether the states can continue to come together to create things like the interim guidelines, the drought contingency plans, the 500 plus plan on their own in order to adapt to these new shortages and this new normal, or whether we do actually have to go back to the body of the law of the river and try to figure out what it all means and what different provisions mean, either on our own in negotiations, whether that's at the behest of the Secretary of Interior saying, hey, you all need to figure this out, or we're going to make drastic changes to how we administer the river, or whether that's at the Supreme Court, which frankly no one wants to do, but whether we can adapt fast enough and be flexible enough under the broad strokes of the law of the river to make these extra compact agreements or not will really determine how we move ahead and at what pace we move ahead. And that's what I told you. I think we've got time for questions, if you have questions.
Thank you.
I have a question about power allocations between the various public power entities that take under CRISP, and how low water is going to impact that.
Sure. So It's a great point. Obviously, we rely on Glen Canyon Dam and Hoover to produce abundant power throughout the Southwest and through the Western Interconnect. And what we've seen over the last years is already a reduction in those deliveries. As the water levels drop, you have less hydraulic head, which means there's less pressure pushing the water through the turbines. The turbines don't spin as fast, you don't get as much power out of it. I'm not actually sure how they've been sharing and allocating those shortages. I'm guessing it's on a pro rata basis from the power supply contracts, but I couldn't tell you for sure. The major concern is as the water levels drop, we'll actually hit an elevation where water can still pass through the dam, but can't actually pass through the turbines. The intakes are separated by, I think, about 35 feet at Glen Canyon. And then obviously the real tipping point is getting below those water intakes where water can no longer get out of Powell downstream to Meade, and then the same thing at Lake Meade. So I think most recently the Interconnect said that about 30% of the power on the grid is hydropower, and most of that comes from these two dams, and to some extent the smaller hydroelectric dams in the area. So that will obviously have a big impact on energy prices going forward, and we already saw some of that last summer where prices increased in response to less hydroelectric power coming out of Glen Canyon and Hoover dams. Sorry I can't answer your question specifically, but that's the broad overview.
I have a question about the tribes.
Mm-hmm.
I think there was a simple provision in the compact about the U.S. Or the compact would not impact U.S. obligations to the tribes.
Mm-hmm.
I mean, how is that going? Are the tribes part of any of these conversations right now?
Yeah, and that's a great question. So to kind of back up a bit, there's 30 federally recognized tribes, and 23 of them, I believe, have secured their water rights in one way or another, either by court decree or through settlement, and others are still negotiating. So the impact of Arizona and California has been felt in that, yes, there is a way forward for them. There's the threat of the practically irrigated standard, which is typically quite high, that forces state governments and the federal government to the bargaining table to figure out what those rights look like. In terms of them having a seat at the table for all of these kinds of negotiations, it's really been a mixed bag. Secretary of Interior actually apologized for the way they handled the interim guidelines negotiations in 2007 because they pretty much completely excluded the tribes from those discussions. And there's an ongoing complaint among the different tribes that they aren't being fully consulted or being treated as co-equal sovereigns to the states in these discussions. And we've seen that a lot where they're kind of lumped in with all the other stakeholders, whether that be irrigation districts, power districts. So I would say that we still have a long way to go in tribal involvement, and it's especially important because right now tribal use of water in the Colorado is about 30%. 20 to 30% of overall use. So it's not insignificant, but the outstanding water rights are genuinely massive. So when we just look at Navajo Claims in Arizona and Lower Basin, Arizona, you're looking at 2 to 5 million acre feet, depending on what standard and calculations you use. But when you say 2 to 5 million acre feet, and where are we at? And Arizona only gets 2.8 under the compact. I mean, there's some serious, as Stanley Pollock puts it, sleeping giants and compact busters out there where, if Navajo were to go to court and receive 2.5 to 5 million acre feet of water from the main stem of the Colorado, and finds a way to put that to use, you're looking at displacing the entire use of Arizona water throughout the state. I don't think that will happen. I think that they will come to a settlement with Arizona in the way that they have with Utah. Settlements generally work out better for the tribes because they come with the funding necessary to actually put the water to use. And that's something that's kind of been learned over the years. The Shoshone and Arapaho tribes in Wyoming in the Wind River adjudication up there, they spent 1978 to 1988 in court. They finally got their decree on the PIA standard. It's enough water to irrigate 100,000 acres, but it's a piece of paper because it came from a court, and the tribes don't have the money to build the infrastructure to put it to use. So in some of these cases, gaining the water rights has been largely illusory. They've turned out to be paper rights, which is why there's such a push now towards settling these between states, tribes, and the federal government. So the Utah settlement, which has taken about 7 years from the time it was agreed on in principle in 2015 between Utah and the tribe, all the way through federal passing of it. The federal government and the state government are putting millions of dollars into the settlement terms. So the Navajo are taking nominally less than they would receive under the court standard in California, Arizona, but they're actually receiving millions of dollars to put those water rights to use. And this is kind of the delicate balance at the negotiating table for each tribe and each entity is, most of these rights are far senior to any state rights, for agriculture, for municipalities, whatever it happens to be. And they don't want to, have their expectations upset. So it's this complex dance of, okay, we recognize your rights are senior. Would you take this much water in these particular ways so that we don't upset the rest of the system that was built on top of your rights, while also giving you the money to actually get water onto the reservation for clean drinking water, agriculture, industry, whatever it happens to be. So that's the big roundabout.
So is there, inside the law of the river, any consideration for return flows, or is that left to the states?
Oh yeah, so this is a great engineering battle that was waged by Arizona and California earlier in the century, where it came down to a question of, is consumptive use really just, you take it out, you put it on the field, and consumptive use is whatever doesn't return to the river there, or is it a question of net depletions at the Colorado? The major difference between them was, can you divert and redivert and redivert and redivert as long as enough of that water comes back from whatever your uses are to the main stem of the Colorado? So the answer is yes, return flows are accounted for, although the way in which it's accounted for is very much, I don't think it's developed enough that you could really use it in an eventual compact conflict, because that argument at the Supreme Court basically would change the allocations from the Boulder Canyon Project Act. That was really what they were looking at then, is, okay, how much water does Arizona get? How much does California get? They argued about it. The Supreme Court said, no, we're just going to go with what the Project Act said. So while return flows are part of it and are used at the state level as part of the law, we don't, I think, really know how that would play out if the lower basin and the upper basin, or any two states, got into a conflict about their internal water use.
Well, I think Colorado is the biggest diverter out of the basin to another basin, never to come back to the Colorado.
Almost. We're the second biggest. California's actually the biggest because almost the entirety of their 4.4 never comes back, and that's because it ends up in the Imperial Valley and then goes into the Salton Sea, or now is increasingly exported out to San Diego and Los Angeles, which puts a stick in our craw that California doesn't actually really contribute anything to the main flow of the Colorado, and yet they take the lion's share of the about 10 to 11 million acre feet that go down it every year. And I guess kind of in closing, as we come up on 50 minutes, there's in all of this ambiguity and a potential compact call where the lower basin says, hey, we're not getting our 75 million acre feet on a 10-year rolling basis anymore. The lines are really drawn all the way back here in Article 3, D and E, that will not cause provision. So it's generally thought that in the upper basin states, it's generally thought in the position that this is not a delivery obligation, and that the cause of diminished flows is not use in the upper basin, especially because we're only using 4.5 or 7.5 million acre feet. The cause of the depletion is climate change, lower basin overuse, the fact that the lower basin isn't charged for its evaporative losses in its reservoirs, and in the lower basin, obviously they read this as, no, it's a delivery obligation. You have to give us 7.5 million acre feet every year. So that seems to be the main point of tension between the basins whenever you ask them to elaborate on what a potential compact call or future conflict would look like. It almost always comes back to this Article 3D, will not cause to be depleted provision. With that, again, Gregor MacGregor, feel free to email me, gregor.macgregor@colorado.edu, especially for the folks watching later if you have questions. You can also support our seminar. So I'm actually taking my 16 students down the Colorado River into the heart of the Grand Canyon after graduation. If they successfully present and defend their research and they survive all of the rapids, I will then hood them down on the beach below lava falls. If their research is not satisfactory, they'll go into lava falls, and if they don't survive in any case, then they won't be hooded. But donations to that are greatly appreciated so that we can offer this really unique, one-of-a-kind experience at CU Law.
Okay.
I'm guessing he can cut from there.
Thank you, Gregor. That was great.
Yeah, thanks for coming in during Snowpocalypse.